Your cell phones aren't probably against them.
Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been actually come to court today or this morning for what we call an arraignment. And what the arraignment is, it's just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Felony cases are commonly referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and a possible punishment that a person can receive if they are convicted of the criminal offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a state jail felony, the range of punishment is minimum, well, the highest felony is a capital murder. So if a person is convicted of a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, the case that you have in this court is a misdemeanor case, so you don't have to worry about those type of punishments. However, with the misdemeanor cases, misdemeanors are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. Person is convicted of a class C misdemeanor, the range of punishment is fine only. Cannot be given jail time, and the fine cannot exceed $500. Now, class C misdemeanors start in the city court or the JP court. They come to this court when a person is convicted in one of those courts, and then they appeal their case. Once they appeal the case comes here. The range of punishment is the same, which means that if a person is found guilty, they can be given a fine that does not exceed $500. Now, if the person fails to pay the fine, or if the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a capias pro fine. That basically means there's a warrant for the rest of the person to pay the fine, or if they do not pay the fine, they have to sit the fine out in jail, and they will be credited $100 per day for every day that they sit out in jail until the fine is paid in full. Now, the next highest misdemeanor is a class B misdemeanor. With the class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. And the highest misdemeanor is a class A misdemeanor. Class A misdemeanor, the range of punishment is minimum 0 days to maximum 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, as I mentioned to you earlier, this is called arraignment. And I mentioned to you that we go over some of the rights that you have. One of the rights that you have as a defendant in a criminal case is your right to have an attorney. Now, the clipboard that has been handed out, everyone that's here for arraignment, make sure you have a clipboard. The clipboard that's handed out, I'm going to go over the paperwork with that because everyone needs to review and sign the paperwork. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. That should be the first document. I see some people have the affidavit first. The first document looks like this. Judge's Explanation of Rights to Defendants Without Attorney. Now, in this document, it states, as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you would like an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number 3, you may represent yourself. Now, if you like to have an attorney, you have enough money to hire an attorney, that's what the first paragraph says, then your case will be reset to give you time to hire an attorney. Second paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to you, but you must first fill out a financial questionnaire. Now, the financial questionnaire is a document on the clipboard. It's a 3-page document that is titled Jefferson County Affidavit of Indigence. Okay, and that document looks like this. Now, you have to fill out the first page of this document. And on the second page, you would have to fill out the top portion that says defendant's oath, and then the middle portion on near the bottom that says unsworn declaration. And then you'll stop. Now, that's for individuals who would like to request a court-appointed attorney. Now, the next paragraph states that you may not speak to the prosecutor. Now, the prosecutor, that's assistant criminal district attorney. We have 3 of them here in court. If you represent yourself, you'll have an opportunity to talk to one of the prosecutors, because at that point, you'll be representing yourself. You'll be your own lawyer. And so you can talk to the prosecutor like your lawyer would be able to talk to the prosecutor. And you'll be representing yourself, but you cannot speak to the prosecutor unless you first sign a written waiver of your right to have an attorney. The written waiver is another document on the clipboard that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea. Now, only the individuals who will be representing themselves will read and sign this document. Okay, now if we go back to the first document, Judge's Explanation of Rights to Defendants Without an Attorney, you'll see a second to the last paragraph that states, be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you, including your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, that's what the last paragraph says, you may change your mind at any time and request that an attorney be appointed to represent you. At the bottom of this document, in bold letters, it states defendant's choice, marking issues next to only one choice. If you would like to have your case reset to hire your own attorney, then you'll place your initials on the first line to the left at the bottom. If you already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you would like to waive or give up the right to have an attorney, and you would like to represent yourself, then you will place your initials on the fifth line to the left at the bottom. Now, once you finish initialing one of the 5 lines that I've just mentioned, you will sign your name on the line that is titled defendant, and you will date it, today's date. Okay. And just for a brief recap, if you like to hire your own attorney, this is the only document you have to sign. You will place your initials on the first line, sign it and date it, and that's it for you. If you would like to apply for a court-appointed attorney, then you have to sign this document on this, put your initials on the second line, sign it where it says defendant, date it. That should be the third line for apply for court-appointed. You put your initials on the third line, sign it where it says defendant, and date it today's date. And then you would have to go to the Jefferson County Affidavit of Insurance, fill out the first page. On the second page, you fill out the top portion that says defendant's oath, and then you'll fill out the middle portion that says unsworn declaration, and then you stop. You won't have to fill out anything else. Now, if you would like to represent yourself, that is, waive your right to have an attorney, give up the right to have an attorney, then you will have to, you go back to the first document, you're gonna put your initials on the fifth line of this first document, judgment, explanation of rights to defendants. Place your signature on the line that says defendant, dated today's date, and then you will have to read and sign this next document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. That's another document on the clipboard. Then you'll sign here and date, and that's it. Okay, anybody have any questions? Yeah.
So what if you, get a court-appointed attorney and you don't like his work?
Well, that's, you put the cart before the horse. At this point, you just, if you want to apply for court-appointed attorney, you have to apply for court-appointed attorney. Okay? That's somewhere down the line. We're not there yet. Okay, at this point, you either want to hire your own attorney, apply for a court-appointed attorney, or represent yourself. Yes,
I'm set for trial, I'm going to.
set the trial where,
What's it in this court over there? They brought me back over here.
what's your name?
Chase Stimble. I got the charge dismissed like last year. They picked it back up 2 years ago and it's been,
We don't have you set for trial. You may have been set for trial over there, but once they, transferred the case over here, it got placed back into Raymond docket, and then if you had an attorney, he, if you had a court-appointed attorney, he rescinded that order. So you do not have a court-appointed attorney at this time. So now you're back to square one. They transferred it from that court over here. Okay? So this is an arrangement. All right? Okay, so anybody else have any questions? Any other questions? Yes,
When I was in, the jail, I filled in all the paperwork for the permit in.
okay. Okay. If you fill out the paperwork, what probably happened, you bonded out of jail,
Yes, sir.
before they, made the appointment. And so this is your first court appearance since you bonded out. And so if you qualify for a court appointed attorney, you will have an attorney appointed today. Okay? All right. All right. Now, anybody else have any other questions? Okay. Now, what we're going to do, I'm going to go over your other rights that you have. One other right that you have a right to have a, jury trial. And where, those young ladies are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence, to listen to the arguments of counsels. They will, retire to deliberate in the jury room, and they will decide whether to find you not guilty or guilty. You also have a right to waive or give up your right to have a trial by jury. What that means is you have a right not to have a trial by jury. And if you waive or give up your right to have a trial by jury, your case will come before this court in one of 3 ways. One way that it can come before the court is by way of a trial. Somebody might say, well, how can it come by way of a trial if I waive my right to a jury trial? Well, you're waiving your right to a jury trial. However, it still can come before the judge for what we call a bench trial. It's a trial by judge only. The judge is the judge and the jury in the case. We call that a bench trial. Now you can, the other way that your case can come before the court is by way of a plea bargain agreement. Now, a plea bargain agreement is just an agreement that you or you and your attorney have worked out with the state to settle your case. And we call that a plea bargain. Now, if you have an agreement, we call that an agreed plea bargain agreement. Now, if you do not have an agreement and you still would like to have your case come before the court, we call that an unagreed plea bargain agreement. Now, with the agreed plea bargain agreement, you have an agreement with the state to settle your case. That case will come before the court, before the judge. The judge can do one of 2 things. The judge can either accept or reject your plea bargain agreement. If the judge accepts your plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, you have to get permission from that judge who accepted the plea bargain agreement. And if the judge gives you permission, your case is going to leave this court and go upstairs to the 9th Court of Appeal, where there are 4 judges who will review your case to see whether or not you've been convicted or whether or not this court committed an error by convicting you. They can do one of 2 things. They can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. Or they can send the case back down to this court in order this court to give you a whole new trial. Now, if they deny your appeal, well, you can appeal it to a higher court than the 9th Court of Appeal. You can appeal it to the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. You will have to file what is called a pro se petition for discretionary review. What that means is, pro se means that you'll be representing yourself and you'll be petitioning the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, or whether or not you was wrongfully convicted, or if this court committed error by convicting you. They can do one of 2 things. They can either grant or deny your petition. If they grant your petition, they can simply find you not guilty, or they can send a case back up to the 9th Court of Appeals, or they can send it back down here to this court ordering this court to give you a whole new trial. Now, the other thing, that they can do, if they deny your pro se petition, then at that point, your conviction will stand. Now, the other type of plea bargain is called an unagreed plea bargain, as I mentioned to you earlier. With the unagreed plea bargain, the judge sets the punishment. In essence, you enter a plea to be either guilty or not guilty, like in a plea bargain. And or either plea or guilty or no contest, excuse me. And it comes before the judge. And then the judge can accept or reject the agreement, if it's an agreed. Now, if it's unagreed, it comes before the judge sets the punishment. That is, any punishment within the punishment range, anywhere from probation or fine, or probation and a fine, depending on what the punishment range is. All right, now, the other right that you have is a right to have witnesses to come to court. That chair that has the microphone in front of it, we call it the witness stand. And witnesses are individuals who are called to testify. They can testify for you, against you. If you represent yourself, you ask a question. If you have an attorney, the attorney can ask a question. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to call witnesses. That basically means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case. You also have what is called a Fifth Amendment right against self-incrimination. What that basically means, you have a right not to testify in your case. The state, the government, the prosecutor, or the district attorney's office cannot force you to take the witness stand if you invoke or exercise your Fifth Amendment right against self-incrimination. Now, you can waive, which means you can waive your Fifth Amendment right. That means give up your Fifth Amendment right against self-incrimination. You can take a witness stand, but that's your choice. Now, you also have a right to have what we call discovery. And discovery basically means you have a right to see the evidence that the state has and you'll be using against you. That is, you have a right to see witness statements, your statements, police reports, lab reports, video recordings, listen to audio recordings. You have a right to see photos, documents, or any type of instruments that the state has in its possession and will be using in the case that it has against you. Now, you also have a right to waive or give up the right to have discovery, which means you have a right not to have discovery in the case because you waive and give it up. Now, everyone that's here this morning for arraignment, you have, charges have been filed against you, been arrested, placed in jail, you bonded out, you read out of jail on a surety bond, which means that you pay the percentage of a bond to get out of jail to a bond, or you're out on a cash bond, which means you pay the full amount of the bond to get out of jail. Or you're out of jail on what we call a PR or personal recognizance bond, which means that you did not have to pay anything to get out of jail, you were just released under your own personal recognizance. I said that to say this. Every day that you spent in jail can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail and then you bonded out. Well, let me back up. Every day that you spent in jail can be used as credit towards your fine and court cost. Notice I said every day. If you were, or let's say you was arrested last night at 12:59 p.m. You got out of jail 2 minutes later you was arrested at 11:59 p.m. and you got out of jail at 12:01 a.m., 2 minutes later. That's 2 different days. You get 2 days credit. You was in jail 2 minutes, but you get two days credit because it's 2 different days. All right. Now, let's say you spent 5 days in jail. Let's say you talked to the prosecutor, you worked out people on agreement. The agreement is for you to serve 5 days in jail. Well, you would not have to serve any more time in jail because you'll be given credit for the time that you have already spent in jail. you'll be given what we call credit for time served. Now, if the state is offering 7 days in jail, you spend 5 days in jail, that simply means you would only have to serve 2 days in jail because you already have 5 days served. So we'll subtract 5 from the 7 and that leaves 2. Now, every day that you spent in jail also could be used as credit towards your fine and court cost. You receive $100 per day for every credit towards your fine and court cost. So if you spend 5 days in jail at $500 credit, that can be used towards your fine and court cost. So if the state is offering fine and court costs of $500, you want to pay anything. Why? Because the 5 days that you served in jail is already paid off. Therefore, it'd be taxed on the top. Now, if they're offering fine and court costs of $700, you spent 5 days in jail, which is $500, we'll subtract the 500 from the 700. That leaves $200 to be paid. Now, if you cannot pay it, no problem. If you cannot, we could put you on a payment plan. Where you'll pay in small monthly installments until it's paid off. Now, maybe your financial situation is such that you will be unable to pay it off even if they put you on a payment plan, no problem. Because the court can convert the fine and court costs to community service. You will receive $12.50 credit toward your fine and court costs for every 1 hour that you perform in a nonprofit organization. So in our scenario, if you serve 8 hours of community service in 1 day, that's $100. So if you do 2 hours of community service, so 2 days of community service, 2 8-hour days of community service, that is $200. So you'll be through with paying off your fine and court costs. Okay. Now, if you have not been in trouble before, Jefferson County has a program that is called pretrial diversion. And with pretrial diversion, what that basically means is they will dismiss your case and you can get it expunged from record. Expunged means wiped off, deleted, or erased from your criminal record. And so in order to qualify for the program, it has to be your first time getting in trouble. It cannot be an offense involving resisting arrest, unlawful carrying a weapon, and you have to get an attorney to assist you with making the application to the district attorney's office. Now, if you're a veteran of any one of the branches of the United States military, Jefferson County DA's office has another program that is called Veterans Court. And with Veterans Court, they will, once you get into the program and complete the program, they will dismiss the case. And once the case is dismissed, you can get what is called a non-disclosure. A non-disclosure is basically when your record is sealed to the general public. Okay? And so notice that's mentioned general public. That's because the government can have access to your record. And there are a list of agencies in the Texas Code of Criminal Procedure that can have access, but most of the public is the general public, so most of the public cannot have access to your record because it's sealed to them. Now, this court has a program that is called the Community Safety Initiative. It's a CSI program. It's a program that God led me to start in March of 2017, within the first 100 days of taking office. That program is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so to address the issue of recidivism, God led me to start the Community Safety Initiative. And with the Community Safety Initiative, we have partnerships in our community with local agencies. One of the agencies that we have a partnership with is Spindletop Center. Spindletop is our local mental health center in our Southeast Texas region. They have the expertise to address mental issues that individuals may have. And basically, with Spindletop, we have some individuals from Spindletop here this morning. They're going to come to you in a few minutes and tell you a little bit more about the program. But basically, what Spindletop will do today, they can conduct what is called a private interview, either in our jury room, at their facility, or by telephone, whichever is convenient to you. Spindletop also has the expertise to do an assessment develop a treatment plan to address whatever mental health needs that you may have. Now, you do not have to be incompetent in saying participate in the program. You can merely suffer from anxiety, depression, or any other host of mental illnesses, and Spinotab has expertise to address your mental health needs. If you have issues with drugs and alcohol, Spinotab has a program that is called ATAR. ATAR is an acronym that stands for Addiction, Treatment, and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR, OSAR, which is an acronym that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do, they will be able to conduct a screening, do an assessment, and then develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed or you're looking for a better job, we have a partnership with the Gold Training Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas that you select, they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school or you do not have a GED, well, they have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free, does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people have too much to lose. In this court, I like to say that we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, then we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. And we have brochures that we can give to you, and we can direct you to people that you can talk to get into any one of the programs that I mentioned. Now, I also mentioned to you earlier that we have some folks in Spinotab. They're going to come here and tell you a little bit more about the program that Spinotab has to offer. We have Deputy Hinton, Caitlin, and Allie. They're from Spinotab.
Thank you, Your Honor. Good morning. Good to be speaking. My name is Steve Hinton. I'm a mental health deputy licensed by the State Commission here with the Sheriff's Department. I have two co-workers, Allie and Caitlin. Now, both these ladies are qualified mental health professionals. The reason all three of us are here this morning in this courtroom is that the judge cares about every single person on the court bench. You see what the judge has found, what's proved is those who have mental issues commonly have mental health needs, such as use disorder, or sometimes just a lack of community resources to help you in your particular situation. Now, maybe this is your first time to be in court, could be your fifth time to be in court. In fact, there's still hope. What we're offering you today has the ability to change your life. We're going to need something from you. We're asking you to share that need with us, and Caitlin's going to explain exactly how you can do that very privately.
In the background that I passed out to everybody when I walked in earlier, at the top is basic information, your name, birthday, phone number, email. We need those things to be able to contact you and to put you into our system. Under that is how you prefer to be contacted, and the options are call, text, and email. Whatever you check is how I will contact you. Whatever you don't check is how I'll contact you. And right under that is what I need help with. And the options under that, most of the time, it's resources that I email to you, and then you have to do the rest yourself. But if you look at mental health, which is depression, anxiety, PTSD, or substance use, which is any type of drug or alcohol, you'll work hand in hand with Spinotab to get you the things that you need. Under that, everything else is self-explanatory, but if you want to talk to me today in person, like the judge said, not pull you to a back room and do a private interview, then just write on your paper that you would like to talk to me today. When the judge calls your name, I'll listen for it and I'll come and get you, and then we can talk when you're done in court. Or if you want me to call you today, please call today. But if you don't care, if I call you any day this week, then just check the call off.
So one of the first resources we can actually provide you today is on this business size card. It has a 1-800 number on there. If you ever find yourself in an unsafe place, you can call that number and get help immediately. We're going to get this out to you today. Now, just shortly, court's going to go into recess. When it does, we'll be able to come out there and we'll visit with you. We'll pick up those documents from you. I'll be handing this out to everyone who wants one, and we'll be able to answer any questions you have at that time. Thank you. Thank you, Your Honor.
Okay, thank you, Deputy Hinton and paper and out. Okay, now, ladies and gentlemen, as Deputy Hinton mentioned, we're gonna be going into recess in a few minutes, and at that point, you'll have an opportunity to finish filling out the paperwork if you need to finish filling out the paperwork. We will pick up that paperwork from you, and then we're gonna call you to the bench one at a time. And we're gonna put you into one of 3 categories, either to hire an attorney, to appoint a court-appointed attorney, or for you to represent yourself. Now, it's gonna take us a little time to pick up the paperwork from you, to go through the paperwork and pick it up. And so if you need to use the restroom, there are 2 restrooms right out in the hallway. The men's restroom is in front of County Court number 3, which is right next door. And the women's restroom is on the opposite side of the hall in front of the 172nd District Court. Now, you'll be allowed to go out in the hallway to use the restroom. Now, please do not leave the courthouse. Leave the courthouse, call your name, you're not here, then your bond can be forfeited. If your bond is forfeited, warrant will be for your arrest, you'll be arrested, placed in jail, you have to go through this process all over again. So at the end, if you need any help with the paperwork, we have our court personnel who's here, including myself, who will be assisting you or helping you to fill out the paperwork. So at this time, we'll be in recess and make sure that, make sure everyone's phone is off. And let's conduct yourself accordingly, because we are still in court. So we're in recess. Okay, the person that's on Zoom that has Emily's iPhone, you can take your mic off of mute and state your full name.
Emily Bankard?
Okay, Emily Bankert.
Yes.
Okay. Now, Ms. Bankert, your case is gonna be reset to give you time to come into court. You have to be in court for the arraignment.
Yes, sir.
So, to sign the paperwork, give us a reset date. Okay, this case is gonna be reset for March 11th.
Okay.
of 2025 at 9 a.m. And you need to stay in contact with your bondsman. You're free to go you're free to go at this time. And again, your court date is March 11 of 2025 at 9 a.m.
Okay.
All right?
Okay, yes, sir. Thank you.
Okay, the next person that's on Zoom is that,
Deshaun Mays?
what is it?
Deshaun Mays?
Mays. Okay. Okay, give us a reset date for Mr. March 11th. Okay. Mr. Mays, your case is gonna be reset to March 11th of
Okay,
2025 at 9 a.m. On that day, you need to be in court in person.
okay,
Okay, 9 a.m., March 11th of 2025. Stay in contact with your bonds. Well, you have a cash bond. But you're gonna be back in court in this court in person, March 11th, 2025. You're free to
okay.
go.
Okay, sir, thank you.
All right, you're welcome. Court is back in session. First case is cause number 25 CCCR 0078. Case is style of State of Texas versus Ravi Ramsarut. Please come forward. Mr. Ramsarut, your full name is Ravi Ramsarut?
Correct.
Ramsarut, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Mr. Ramsarut? That's good. Mr. Ramsarut, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, yes,
Is this your signature on the
Yes.
line that's titled Defendant?
yes,
And are these your initials on the line that
Yes.
state you'd like to apply for court-appointed attorney?
yes,
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
yes,
On page 2 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
it is. Yes.
Mr. Ramsarut, before you sign and initial these documents that I just showed you, did you read the documents?
I did.
You understand what you read?
I did.
Is everything in these documents true and correct to the best of your knowledge?
It is.
Okay, Mr. Ramsarut, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. Before she gives you that information, I need to give you some bond conditions. The bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title? County Standard Bond Conditions in County Court at Law Number 2.
Mhm.
And it states as follows: following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
I do.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test in the case the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
I understand.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. The defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that
I
condition?
understand.
Condition number 4 does not apply. That only applies in a DWI case. Your case is not a DWI case. However, condition number 5 does apply. Condition number 5 says defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that
I
condition?
understand.
Now, Mr. Ramsarut, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in Jefferson County Jail. Do you understand?
I understand.
Okay, Mr. Ramsarut, please have a seat in that first chair on the wall and wait for your name to be called. Justin Woods. Mr. Woods, your full name is Justin Aaron Woods.
Yes, sir.
Woods, would you please raise your right hand? Woods, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. I do.
Mr. Woods, you may put your hand down. How are you doing, Mr. Woods?
I'm doing.
That's good. Mr. Woods, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this same document, there is a signature above the line that's titled defendant. Is this your signature? Yeah. Mr. Woods, before you sign and initial these documents that I just showed you, did you read the document? Did you read these documents?
Yes, sir.
Okay, did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
I believe so.
Okay. Now, Mr. Woods, I read your answers. That door is locked, sir. You gotta go through the other door. I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you can follow the bailiff. Just please have a seat in the jury box. Edgar Maddox. Mr. Maddox, your full name is Edgar Maddox? Okay, Mr. Maddox, would you please raise your right hand? Mr. Maddox, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Mr. Maddox? Fair? That's good. Now, Mr. Maddox, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant? Or are these your initials on the line that states you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled defendant signature. Is this your signature?
Yes, sir.
Mr. Maddox, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Maddox, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Jennifer DeLage. Attorney DeLage will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall. Jacoby Holland.
There you go.
All right, Mr. Holland, your full name is Jacoby T. Holland.
Yes, sir.
Mr. Holland, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Holland, you may put your hand down. How are you doing, Mr. Holland? I'm doing fine, thanks for asking, Mr. Holland. I have before me a document that is titled Jefferson County Affidavit, but it's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Mr. Holland, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Holland, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in your case is Attorney Lori Perazzo. Attorney Perazzo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go on your blessed day. Please have a seat in the second chair on the wall.
Yes, sir.
Edwin Mahia. Oh, Mr. Mayor, just have a seat. While you later. Christian Madrano. Mr. Madrano, your full name is Christian Thomas Madrano?
Sir.
Okay, Mr. Madrano, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Madrano, you may put your hand down. How are you doing, Ms. Madrano? You blessed? Can't be better than being blessed. Now, man, Mr. Madrano, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Now, Mr. Madrano, do you have some gum in your mouth? There's a trash can right there by the side, and you take it out of your mouth. Okay, now, Mr. Madrano, this document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there is a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Mr. Madrano, before you sign and initial these documents, did you read the documents?
Yes, sir.
You understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Madrano, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you'll have a blessed day. Please have a seat on that in that second chair on the wall. Chase Kimball. Mr. Kimball, your full name is Chase Kimball. Mr. Kimball, would you please raise your right hand? Mr. Kimball, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Kimball, you may put your hand down. How are you doing, Mr. Kimball?
Oh, pretty good.
That's good. Now, Mr. Kimball, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's
Yes, sir.
titled Defendant? And are these your initials on the line that states you like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
Defendant?
sir.
Mr. Kimball, before you signed and initial these documents, did you read the documents? Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to
Yes,
the
sir.
best of your knowledge? Okay, now, Mr. Kimball, earlier you had an opportunity to talk to one of the prosecutors in the case, is that correct? And they made an offer and you rejected it, is that correct? Now, Mr. Kimball, I need to ask you some questions pursuant to the case of Ferretta versus California, 422 US 806. Have you ever studied law?
No.
Have you,
I mean, I read some books, but not like what you consider studying, like went to college or.
right. Have you ever represented yourself in a criminal action? Have you, well, do you understand the charges against you? Are you aware of the penalty range?
Yes, sir.
Okay. Are you familiar with the exact legal elements for each charge?
Yes, sir.
Okay. Do you realize that, if you represent yourself, you're on your own?
I've tried to use two attorneys so far, like, and we go all the way to trial and then they just,
Okay, well, but my
Don't-
question was, do you realize that if you represent yourself,
Yes, sir.
you're on your own?
yes, sir.
Now, as a judge, I cannot tell you how you should try your case or even advise you as to how to try your case. I cannot help you in any way. Do you understand? Are you familiar with the Texas Rules of Evidence and Texas case law?
No, but I will.
Okay. Do you realize that Texas Rules of Evidence, Texas case law govern what evidence is admitted, and in representing yourself, you must abide by those rules? For example, how do you conduct a voir dire examination?
I do.
Okay. What are the grounds for excusing a juror for cause?
If they had like a opinion, like something happened in their life, it could make them partial to like leaning one way towards something, or, what'd you say, what was the question again?
The question was, what are the grounds for excusing a juror for cause?
For cause,
Yes.
that's how I think it would be. And they might be impartial because something happened in their life or something like that. We didn't get that far anyway, and worry about it.
Okay. What is hearsay? You know what hearsay is? Do you know what are some of the exceptions to hearsay? You don't? Do you know what is proper impeachment of a witness?
That's-
Or when character evidence is allowed?
I know what it means.
Do you know when it's allowed in a trial?
When character witness is allowed.
Character evidence is allowed in the trial.
No.
Do you know how and when to make a proper objection?
Yeah.
Okay.
When it's kind of irrelevant or like a hearsay.
There are several objections that a person could make. That's just two of one of many. Okay. Do you know when and how to move for a directed verdict? Do you know how to offer evidence to protect the record for appeal? Do you know the proper grounds for mistrial?
No. Yeah.
Are you aware that the failure to timely move for a mistrial may waive crucial mistakes made by the court or by this court? Do you understand that?
Yes, sir.
Do you know how to request and object to a jury instructions? Are you familiar with the Texas Rules of Criminal Procedure? Do you realize that those rules govern the way in which a criminal action is tried in court? Okay. Now, I must advise you that, in my opinion, you would be better defended by a trained lawyer than you can by yourself. I think it is unwise for you to try to represent yourself. You are not familiar with the law. You're not familiar with court procedures. You're not familiar with rules of evidence. I would strongly urge you not to try to represent yourself. Now, in light of the penalty that you might suffer if you are found guilty, in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a lawyer?
I want to represent myself.
Okay. Is your decision entirely voluntarily on your part?
Yes, sir.
Okay. I find that the defendant has knowingly and voluntarily waived his right to counsel. I will therefore permit him to represent himself. Okay. So at this time, Mr. Kimball, your case is going to be reset. It's going to be reset to give you time to make an appointment with the district attorney's office to have discovery. In essence, that is, you can have access to the evidence that they have in the case that they'll be using against you. Okay? And so, hold on, I'm not through. And so, you need to set up an appointment with one of the prosecutors. Whose case is this? Do we know? Okay, so you need to set up an appointment with Attorney Haley Simmons, to go and have discovery. And I guess at this point, we'll just put his case on the trial docket.
Yes, you are.
Okay, let's put his case on the trial docket. Okay, so your case is gonna be reset for trial March 31st of 2025. Okay. Joshua Fano. Okay, this is cause number 25 CCCR 0028, case of style state of Texas versus Joshua Fano. Mr. Fano, is that your full name? Fano, would you please raise your right hand? Fano, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Fano, you may put your hand down. How are you doing, Mr. Fano? You doing all right? That's good. Now, Mr. Fano, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line as titled defendant?
Yes,
Are these your initials on the line that state you'd like to waive your right to attorney and represent yourself?
yes, sir.
I also have a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding the Trial. You recognize this document? Is this your signature on the line as titled defendant? Mr. Fontenot, before you sign and initial these two documents, did you read the documents? You understand what you read? Is everything in these documents true and correct to the best of your knowledge? Now, Mr. Fontenot, you had an opportunity to talk to one of the prosecutors this morning about your case to see if you can work out a plea bargain agreement. Is that correct?
Yes.
And you rejected the agreement. Do you still want to go forward in representing yourself? Okay. Now, Mr. Fontenot, I need to ask you some questions pursuant to the case of Ferretta versus California 422 US 806. Have you ever studied law? Have you ever represented yourself in a criminal action? Do you understand the charges against you? Are you aware of the maximum penalty for the charge? Are you familiar with the exact legal elements for each charge or for the charge?
Yes, sir.
You are?
Mhm.
What are the elements?
Oh, wait a minute.
Okay. Okay. Do you realize that if you represent yourself, you're on your own? As a judge, I cannot tell you how you should try your case or even advise you as to how to try your case. I cannot help you in any way. Do you understand that? Are you familiar with the Texas rules of evidence and Texas case law?
Yes, sir.
You're not. Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted, and in representing yourself, you must abide by those rules? For example, how do you conduct a voir dire examination? You don't know. What are the grounds for excusing a juror for cause? You don't know. What is hearsay?
Yes, sir.
Well, it's not gossip, but what are some exceptions to hearsay? You don't know. What is proper impeachment of a witness? You don't know. When is character evidence allowed? You wouldn't know. Do you know when and how to make proper objections? Okay. Do you know when and how to move for a directed verdict? Do you know the proper evidence to protect the record for appeal? Do you know proper grounds for mistrial? Are you aware that failure to timely move for mistrial may waive crucial mistakes made by the state or this court? Do you know how to request and object to jury instructions? Are you familiar with the Texas Rules of Criminal Procedure? Do you realize that those rules govern the way in which a criminal action is tried in court? Okay. Now, I must advise you that, in my opinion, you will be far better defended by a trained lawyer than you can by yourself. I think it is unwise for you to try to represent yourself. You're not familiar with the law. You're not familiar with the court procedures. You are not familiar with the rules of evidence. I would strongly urge you to not try to represent yourself. Now, in light of all the penalty that you may suffer if you're found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by an attorney? Still want to represent yourself? Okay, is your decision entirely voluntarily on your part? Well, I find that the defendant has knowingly and voluntarily waived his right to counsel. I will therefore permit him to represent himself. Now, your case is going to be reset to give you an opportunity to get discovery. That is, you would have to set up an appointment with the district attorney's office. Whose case is this? Is yours as well? Okay, so you'll have to set up an appointment with Attorney Haley Simmons with the district attorney's office so that you can go and have access to the evidence that they have against you. Okay? Now, your case is going to be placed on the announcement docket. Okay, we're going to place the case on the announcement docket. Our court coordinator is going to reset your case. Once you reset your case, you'll be free to go. You have a blessed day. Give me a court date. Okay, this case will be reset to March 31st. Once you get your reset, you're free to go and you have a blessed day. Jennifer. Okay, how you doing, Jim? Pablo Santos Zampop. Okay, Mr. Zampop speaks Spanish. I guess he probably speaks some English. Ms. Araji, would you please raise your right hand? Mr. Araji, do you swear to interpret Spanish to English and English to Spanish, so help you God?
Yes, sir.
Okay. You may put your hand down. How are you doing?
Good, Judge. Thanks
That's
for
good.
asking. How are you?
I'm doing fine. Thanks for asking. Now, ask Mr. Zampop if his full name is Pablo Isaias Santos Zampop.
Su nombre completo es Pablo Díaz Santos Lampa?
Yes.
Yes, Judge.
Ask Mr. Zampop to raise his right hand.
Mhm.
Okay. Mr. Zampop, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Yes, Judge.
Okay, you may put your hand down. How are you doing, Mr. Zampop?
Okay.
Good? Okay. Now, Mr. Zampop, I have before me two documents. The first document that I have is titled Judge's Explanation of Rights to Defendants Without Attorney. Ask Mr. Zampop if he recognized this document.
Tienes que decir sí o no. Si lo puedes ese documento que tomaste. Yes.
Ask him if this is his signature on the line as titled defendant.
Y ese es su firma completo ahí.
Sí.
Yes.
And are these his initials on the line that states he'd like to apply for court-appointed attorney?
Y también sus iniciales dicen que- Yes, Judge.
Also, I have another document that is titled Jefferson County Affidavit of Injuries. Ask him if he recognized this document.
También de- Yes.
On page 2 of the same document, there's a signature above the line that is titled defendant's signature. Ask him if this is his signature.
Y ese es su firma ahí. Yes.
You asked Mr. Zampop, before he signed and initialed these documents, did someone go over these documents with him in Spanish?
Antes de firmar, ya ponía sus iniciales en esos documentos. Alguien te explicó todo en español.
Un poquito mejor.
He said most of it, but not all of it.
Well, did he understand some English?
¿Entiendes inglés? A little bit.
A little, okay. So it was, he understand a little English and someone helped him in Spanish.
¿Entiendes por qué por inglés y algo en español? Yes, Judge.
Okay, now. Is everything in these documents true and correct to the best of his knowledge?
Y todo en esos documentos, ¿verdad? Yes, Judge.
Okay, Mr. Zampop. I read your answers. Based on your answers, you meet the eligibility requirements for a court-appointed attorney. And the attorney that will be appointed to represent you, Attorney Charles Rojas. He's fluent in Spanish and English. Our court coordinator is gonna reset your case. She's gonna give you information on how to contact Mr. Rojas. And Mr. Rojas will be given information on how to contact you. Please go in front of the court coordinator. Get your case reset. Once your case is reset, you're free to go and you have a blessed day. Okay, thank you, Mr. Rogers. You have a blessed day as well.
Thank you.
Roberto Rubacapa. Okay. Your full name is Roberto Rubacapa. Please raise your right hand. Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. How are you doing? I'm doing fine, thanks for asking. Now, Mr. Rubacapa, I have before me two documents. The first document is titled Judge's Explanation of Rights and Defendants Without Attorney. You recognize this document? Is this your signature on the line as titled defendants? Or these your initials on the line that state you'd like to apply for a court-appointed attorney? I have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? And on page 2 of this same document, there's a set of initials. Well, there's a signature on the line that's titled defendant signature. Is this your signature?
Yes.
Now, Mr. Rubalcaba, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, now, Mr. Rubalcaba, I read your answers. Need to ask you some questions. Qualify for an attorney just because you don't have time to get an attorney. You qualify for an attorney based on your ability to hire an attorney. Okay? And the reason why I was asking this, I saw you put $3,000 a month.
That's weekly,
Oh, well, it asks, well, what you get a month?
like 9.
Oh, okay, well, that's 4 times. Well, you don't, I can tell you right, we can cut to the chase. You don't qualify for a court-appointed attorney.
So the thing is, it could work on the days because I leave offshore.
I understand. No, we'll give you time to hire an attorney. Okay?
I'm not from here. Do you have like a list of good attorneys here?
I can't refer no attorney to you.
It has to be from Beaumont. It can't be from the Valley because I have attorneys in the Valley.
You can hire an attorney who anybody could practice anywhere in the state of Texas.
All right.
They don't have to, yeah.
We'll do that.
Okay, so let me see, so you do not meet the eligibility requirements for the appointment of a court-appointed attorney. Now, Mr. Papara, I need to get him, oh. We're gonna strike through that. And just, he would have to put his initials on the top, on the first line right here.
Okay,
He has a pen.
you got a pen?
You're gonna put your initials on the first line saying you wanna hire an attorney. Just. Okay. Okay, so your case is gonna be reset to give you an opportunity to hire an attorney, but before we do that, I need to give you some bond conditions.
We work on the reset dates.
We'll give you a reset. Okay, if the document that you have before you is titled Standard Bond Conditions in County Code Law Number 2, do you see that title? I'm gonna go over these bond conditions with you. And it states as follows: following the return of a criminal information in County Code Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendants shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test in the case of presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 does not apply because that only applies in a DWI case. Your case is not a DWI case. Your case is an unlawfully carrying a weapon case. Now, the next condition is condition number 5. Defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition? Now, if you violate any one of these conditions, your bond will be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. You understand that? Okay. Okay. Your case is gonna be reset. Please, oh, well, we need to give, now, you say you live in the valley?
Yes, but I'm working here in Motil till 2 weeks. Then I'm going offshore,
How long you gonna be offshore?
like 50 days. For like 21 days, come back 2 days, and then they just let me off in the orders. I have to go back.
Okay. Now, we're gonna reset your case for 60 days. Now,
The thing is,
if
we
you
have-
hire an attorney, your
Yeah.
attorney can send the court a letter of representation saying that they represent you. And then when they do that, your case is gonna be reset to another further court date. Okay? So you have 60 days to hire an attorney.
I'll do that before.
Okay,
I'll do that before the 2 weeks.
that's fine. That's fine. And have your attorney have to send a letter of representation notifying the court that they've been hired and your case will be reset to give you more time. You might have to get in contact with your attorney to give him your schedule so that we'll know when you'll be back on shore for your court dates. Okay. Now, if you happen to be offshore, if there's an announcement or something, you can appear via Zoom.
Oh, yeah.
Okay.
That could work.
All right. Just have a seat, wait for your name to be called. Now, Mr. Mahia, hold on, he showed up with some shorts. Okay. You're gonna have to probably bring him in the back and see if they can get some clothes for him. Is where they pay a bondsman a percentage of the bond to get out of jail. And, or they are out of jail on what we call a PR bond or personal recognizance bond. And with a PR bond or personal recognizance bond, they do not have to pay any money to get out of jail. They are released under their own personal recognizance with a promise to appear here in court. Now, the arraignment is the first time they come to court after being released from jail. Okay? And so with the arraignment, we tell them what their rights are, what the options are, and what other options they have concerning their case. Now, everyone that came in here this morning they had to fill out some documents. And we have a document that is titled Judge's Explanation of Rights of Defendants Without an Attorney. And this tells them about the rights that they have to have an attorney. You know, and that is, they have a right to hire an attorney. They can request a court-appointed attorney, or they can represent themselves. I know you saw some individuals, at least two individuals, who stated that they wanted to represent themselves. With those individuals, we have to give them a warning. We have to ask them questions and then give them a warning. If they still want to go forward, if they knowingly and voluntarily waive their right, they have a right to represent themselves. Now, individuals who apply for a court-appointed attorney, they must be determined to be what we call indigent. Indigent is they don't have the financial ability to hire an attorney. And so there's a form that we sign on that clipboard. It's called Jefferson County Affidavit of Indigence. They fill that out. And then once they fill that out, the court has to make a determination as to whether or not they qualify for a court-appointed attorney. And the other category that we normally put them in is if they want to represent themselves. And if they want to represent themselves, then we have to tell them about the dangers and disadvantages of self-representation. You know, waiving their right to an attorney representing themselves may result in the worst outcome for them, including, in their case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. But if they still want to represent themselves, then we can tell them that they may change their mind at any time and request that an attorney be appointed to represent them. Okay. Now we're going to continue with our last case, Edwin Mejia. Okay, Mr. Mejia, would you please come forward? Mr. Mejia, would you please raise your right hand? Mr. Mejia, did you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Mejia, you may put your hand down. How are you doing, Mr. Mejia?
I'm sorry about that.
Yeah, we got a sign on the door, no shorts, no tank tops. There's a whole bunch of other stuff. You have to read the sign before you come in. Okay? And so you're gonna be coming to court again, so you don't wear no shorts, tank tops, flip-flops, or anything of that nature.
Yes, sir.
All right. Now, Mr. Mejia, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that states you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Mr. Mejia, before you sign and initial these documents, did you read the documents?
Yes,
Did
sir.
you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Mejia, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Marva Provo. Attorney Provo will be given information to contact you. You will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Make sure you return the pants. Okay. Okay. So, now, ladies and gentlemen, when individuals come before the court, we also tell them about their rights. And the first right that we talk about is the right to have an attorney. And as I mentioned to you earlier, they can hire an attorney, they can request a court-appointed attorney, or they may represent themselves. They also have a right to have a trial by jury. That area over there where those 12 chairs are sitting, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in their case. And the reason why we have 6 is because this is a misdemeanor court. We have 6 jurors. In the felony court, they have 12 jurors. So 6 individuals will be selected, serve as jurors. They will listen to all of the evidence, listen to all of the arguments of the attorneys. They will retire to the jury room to deliberate, and they will decide whether or not to find the person not guilty or guilty. Person also have a right to waive or give up a right to have a trial by jury. What that means is they have a right not to have a trial by jury. And if they do so, then their case will come before the judge in one of 3 ways. One way it can come before the judge is by way of a trial. We call that a bench trial. It's a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to all of the evidence, listen to the arguments, apply the facts to the law, and decide to find the person either not guilty or guilty. Now, individuals also have a right to have witnesses to come to court. That chair that's behind the microphone over there is called the witness stand. And what witnesses do, they can testify. They can testify for you or against you. If you're representing yourself, you can ask them questions. Or if you have an attorney, your attorney can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. Now, if you waive or give up your right to have witnesses to come to court, that just simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case. And if they call witnesses in the case, as I mentioned to you earlier, you have a right to ask them questions. We call that either direct examination or cross-examination. Now, individuals also have what is called a Fifth Amendment right against self-incrimination. That simply means that they have a right not to testify. I know a lot of times we watch television, like Law and Order, and we see a police officer goes up to an individual, or you see an individual on the witness stand, and then when they ask them a question, they say, "I take the fifth." And what that means is they are exercising the Fifth Amendment right of the United States Constitution not to testify. The state, the government, the district attorney's office cannot force you to give up your Fifth Amendment right against self-incrimination. You can voluntarily give it up, and if you do so, you will be testifying. But if you do not give up your Fifth Amendment right, they cannot force you to testify in your case. You also have a right, what we call discovery. Defendants have a right to have discovery. Discovery is they have a right to see the evidence or discover the evidence that the state has in its file. They have a right to have access to it. They have a right to see witness statements, their statements, police reports, lab reports, photos, video recordings, audio recordings. You can go. Yeah. They also have a right to see documents or instruments or any type of evidence that the state will be using against them in the case. Now, they can waive or give up that right as well. Now, everyone that came into court today for arraignment, as I mentioned to them earlier, they were arrested, placed in the jail, they bonded out of jail, and they got out of jail on a bond. Now, every day that they spent in jail can be used as credit toward their punishment. And the operative word that I use is day, every day. So, for example, if somebody was arrested at 11:59 a.m., 11:59 p.m. on last night, and they bonded out of jail 2 minutes later at 12:01 a.m., that's considered 2 days because it's 2 different days. So they get 2 days credit. So if a person stayed in jail 5 days and they worked out a plea bargain with the state to serve 5 days in jail, they will not have to serve any more time in jail because they'll be given credit for the time that they have already served. Now, if the state is offering them 7 days and they stayed in the jail 5 days, they will only have to serve 2 days because we will subtract 5 from 7 and that leaves 2. Now, every day that they're spent in jail also can be used as credit toward their fine and court costs. They're credited at $100 per day for every day that they spent in jail. So if they spent 5 days in jail, they have 5 days credit, they're $500 credited toward their fine and court costs. So if the state is offering them fine and court costs of $500, they have $500 on the books. They don't have to pay anything because the fine and court costs will be what we call taxed and retired. Now, if the state is offering, for example, $700, they will only have to pay $2 because they already have $500 that's already on the books. We'll subtract the 500 from the 700, that leaves 200. Now, if they cannot pay it, no problem. We can put them on a payment plan where they can pay small monthly installments over a period of time. Now, some people cannot pay even if we put them on a payment plan, and so we can convert their fine and court costs to what we call community service. Community service is where they will work at a nonprofit organization in our community, and they will be given accredited $12.50 for every hour of community service that they're performing. At $12.50 will go toward the payment of their fine and court costs. Now, Jefferson County District Attorney's Office has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. That is, individuals who have never been in trouble before, first time getting into trouble. The district attorney's office can put them in a program and dismiss their case. And they can get it expunged from their record. It's expunged means removed, wiped off, erased, or deleted from their record. Now, the way it works, it has to be your first time getting into trouble. And then 2, you have to have an attorney to help you to make the application out to the district attorney's office. And then 3, it cannot be an offense for unlawfully carrying a weapon or resisting arrest. And if they qualify, again, the case is dismissed, they complete the program, they can get it erased, deleted, or wiped off, or removed from their criminal record. Now, if individuals are, let's say a person is a veteran of one of the branches of the United States military, the district attorney's office also has a program that is called Veterans Court. It's for veterans only. Once they get into that program and complete the program, the case is dismissed, and then they can get what is called a non-disclosure. And what a non-disclosure is, it means that their record is sealed to the general public. The operative word that I'm using is general public. The government can have access to it. There are a list of agencies that can have access, but most of the public is the general public, so most of the public cannot have access to that record. Now, this court, County Court at Law number 2, has a program that God led me to start within the first 100 days of taking office in March of 2017. That program is called the Community Safety Initiative. We call it the CSI program. With that program, the program is designed to address what we call recidivism. Recidivism is where people commit crimes over and over. And then, well, we have that program to address the issue of recidivism. And the way we address it is through partnerships. Earlier today, we had folks from Spindletop who was here. Spindletop is our local mental health center. And with Spindletop, what Spindletop does, Spindletop comes into the courtroom and they can do a private interview either in our jury room, at their facility, or by phone, whichever is convenient for them. For the defendant, also, they can do what is called an assessment to determine what the mental health issue is, and they can develop a treatment plan for either outpatient or inpatient treatment. Now, with Spindletop, to get into the program, you do not have to be incompetent or insane. You can just merely suffer from anxiety or depression, and they can address your mental health needs. If individuals have issues with drugs and alcohol, and it's not uncommon for individuals to have issues with drugs and alcohol and commit crimes, then Spindletop has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. And we have a partnership with our local drug and alcohol council that has a program that is called OZAR. It's an acronym that stands for Outreach Screening, Assessment, and Referral. Both of those programs are alcohol and drug recovery programs. Now, if individuals are unemployed, do not have a job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once individuals are trained in any one of those areas, then they will assist them at getting a job in the area that they're trained in. And if they do not have a high school diploma or a GED, CICE also has a GED program where they can receive a graduate equivalency diploma. Now, all of these programs that I just mentioned are free. It does not cost them anything but time. And I like to say in this court, we do not just give time, we take out time. That is, we do not just arrest the problem, we address the problem. And if we address the problem, we can produce productive people. If we produce productive people will not commit crimes because they have too much to lose. And therefore, I say that when you come to County Court at Law number 2 of Jefferson County, Texas, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So, so what we also do, we give individuals all of the necessary tools to get into these programs. We have brochures and we have contact information that we can provide to them. Our program is designed not only to connect, but it's designed to empower, and it's designed to correct behavior in our communities. And so this program is designed to break the cycle. And the cycle starts with an individual who did not have education, can't get a job. He can't get a job. He usually gets depressed. Once he gets depressed, he turns to drugs and alcohol. Once they turn to drugs and alcohol, they eventually commit a crime. Once they commit a crime, they eventually get caught and do time. And once they do time, they get out and they're back into the cycle. And so that's what we'll do here in County Court at Law number 2. Now, you still working on the plea? Okay. Now, you're going to witness what we call a plea in a few minutes. But before we do that, every courtroom that you go into around the United States, even though they look different, they all are laid out the same. Okay? Now, the area that you're in any court, is called the peanut gallery. Okay? It doesn't mean you can bring peanuts in here and eat, because this is not the Texas Roadhouse. Okay? Now, that wall that separates this space from the peanut gallery is called the bar. Okay? The bar. And only individuals who can pass that area is lawyers who have passed the bar exam. Okay? When you go to law school, you finish law school, you have to take an examination. It's called a bar exam. Once you pass the bar exam, you're allowed to freely come back and forth. Now, you're allowed to come past that area if the judge gives you permission, if you're not a lawyer, or if you're part of the court personnel. The area that he's sitting in, the bailiff, that's called the jury box, okay? That's where the jurors sit. They sit in that area and they listen to all of the evidence that is being admitted in the court. The chair that's has the microphone in front of it, that area is called the witness stand. And that's where witnesses testify. This area right here is called the bench. This is what a judge sits. Every court that you have has a bench. Okay. Now, the two tables that's in front of the bar, where you see the attorney sitting, we call that counsel's table. You have, imagine a boxing ring, okay? You have two combatants, one in one corner, the other in another corner, okay? You have, on this side, you have the state of Texas. On this side, you have the defense, okay? And so they're the two competing parties in the case. You know, the state, we have 3 prosecutors that are sitting at a counsel table. They work for the district attorney's office. You have attorney Andrew Hubel, you have attorney Shane Hilton, and you have attorney Haley Simmons. Now, the attorney at the next table is a defense attorney, who is attorney Jennifer DeLodge, okay? And she has a case in this court we'll be handling in a few minutes, and she's representing her client, who is in the orange. Now, to my right, we have one of our court coordinators, Ms. Glenda Segura, and the other young lady that was here earlier, who works on the other computer, is our assistant court administrator, Ms. Berla Jackson. And so normally we'll have a court reporter here to my left, next to the witness stand. Okay, a court reporter takes down or types down everything that's being said. In essence, she's keeping what we call a record. County court at law is a court of record. So there's a court reporter that dictates everything that's being said, because, for example, let's say if a person decides they think they've been wrongfully convicted, or this court committed an error by convicting them, they would like to appeal their case. What an appeal is, they'll have a higher court to review what happened in this court to see if the person was wrongfully convicted or whether or not I committed an error by convicting them. And so they need to have a record. That record goes up to the Court of Appeals. And the reason why I say up is because they're located right above us on the 3rd floor. There are 4 judges there that review cases. We call them the 9th Court of Appeals. And they can decide whether or not they can deny or grant an appeal, okay? And so normally on Mondays in this courtroom, we have our jury dockets. We have a jury docket, pretrial conference docket, and announcement docket. And if we had a trial, our trials will start at 1:30 in the afternoons. On Mondays, juries are picked. On Tuesdays at 1:30, we usually have testimony, where the evidence, where the state is putting on the case, okay? Does anyone have any questions? Yes.
Someone wants to represent themselves.
Well, they have a right to. First of all, they have a right to. That's all I can say. They have a right to represent themselves, but as to getting into exactly why, I have no idea. Okay, as long as they knowingly and voluntarily waive their right to an attorney, they have a right to represent themselves. Now, normally, when the person represents themselves, okay, say in a trial, I usually appoint a standby attorney, okay? The standby attorney does not represent them, but the standby attorney is there for advice. They can ask advice. For example, like when I asked the gentleman, does he know how to pick a, to conduct a voir dire? I think that was the question. Voir dire is basically, to tell the truth, when you're picking a jury. So he didn't have no clue. Now, if he's representing himself, he has a lawyer sitting to his left. He could ask the lawyer questions. The lawyer can't pick the jury for him, but he can answer any question that he has or that he has, okay? But normally we have a standby attorney there to advise them while they are trying the case by themselves. And we've had people try the case by themselves. Okay, that happens. Anybody else have any other questions? They're kind of quiet today. Let me ask you, okay, now how many people are interested in being a lawyer? Okay, you already a lawyer. Okay, good. I mean, you should have some questions about the field of law or about what, because you're going to be working in a courtroom for the most part. Most lawyers, on a daily basis, you're in a courtroom, especially if you're on the criminal side. You're prosecutor or defendant, you're in the courtroom every day for the most part. Now, if you're doing civil law, you may not be in court every day. Okay. You only come to court a couple of times. But if you're in criminal law, you're basically in court every day. Yes.
So, by the way, if that individual that wants to represent themselves, if they so happen to not want to represent themselves anymore, would that standby lawyer be appointed or would someone else be appointed?
Well, I mean, at that point, I mean, we'll have a dilemma because for the most part, the standby, okay, first, let me just get back to once a lawyer is appointed or hired, the lawyer is going to conduct an investigation. The lawyer is going to get with the district attorney's office. They have what we call discovery. The lawyer may hire investigators, etc. To try the case, the lawyer is going to be communicating back and forth with the district attorney's office. The lawyer is going to prepare a defense. Okay. If the person decide that I no longer want to represent myself, that lawyer don't have time to do all of that at that point. You see? Because they've already cast the die saying, I want to represent myself. And so we can give you some, well, you can ask advice, you can give advice to you. It is incumbent upon them to try to learn the law and prepare for a trial. Which, I mean, some people some people can do it, but just putting a lawyer on the spot saying, okay, now you take over, I don't think that would be a wise thing to do. Okay. Yes.
On the judge's explanation of rights to defendants without an attorney, it says, you may change your mind at any time. Says that like any time prior, so you can't get.
Well, they say you may change your mind at any time and request that an attorney be appointed to represent you. So that any time, that's why I said, the dilemma that we had in his scenario is we're in trial, right? Now, I guess in order to allow that to happen, a mistrial has to be declared. You understand what I'm saying? Because once a mistrial would have to be declared, and then we go back to square one with the attorney being given an opportunity to prepare for trial. I know the law says you can give them 10 days, but but when we talking trials, it usually take a little bit more time than just 10 days in which to prepare for trial, depending on how complex the case is, because cases could be complex. Okay, everything is just not real simple, cut and dry. Yes.
Have you ever had an instance where the individual was not possible, it was no possible way that individual would be able to represent themselves with like having a positive outcome. Wait, I asked that wrong. Let me ask that. So, let's say a murder case happens, and that individual wants to represent themselves,
That has happened.
on their own, but you know, as a judge, that it's no possible way that they can represent themselves and be free. How do
I
you
mean,
look at that as a judge?
I think if you notice in the questioning that I asked, we have to go through a list of questions. And then if the person still persists on wanting to represent themselves, as long as it's knowingly and voluntarily, we can allow them to do that. Okay, because they have a right to represent themselves. You have a right to have an attorney, but you also have a right to waive or give up your right to have an attorney. Okay, yes. Yeah. Matter of fact, years ago, I was a standby attorney for a gentleman who represented himself and he won the case. That happens. I don't know how often it happens, but it has happened.
Judge Holmes, we went to Judge West Court last month, and could you explain the difference between misdemeanor court?
Okay. Okay, now, in misdemeanor courts, well, criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of the state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If they are convicted of a third-degree felony, the range of punishment is minimum 2 years in the state penitentiary to a maximum of 10 years and a fine that does not exceed $10,000. If they are convicted of a second-degree felony, the range of punishment minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If they're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Okay? Misdemeanors are divided into 3 categories. You have the Class C misdemeanor. Well, we start at the top. We have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, with the Class C misdemeanors, those are cases that start off in the JP court or the city court. Those cases come to this court when a person is found guilty in the JP court or the city court and they appeal their case. In essence, they get a new trial. It comes back up here, we go to square one. The range of punishments is still the same. It's by fine only. The fine cannot exceed $500. Now, however, if a person failed to pay the fine, or if the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a capious pro fine. A capious pro fine is a warrant for their arrest for them to either pay the fine or sit the fine out in jail at $100 per day. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, if a person is convicted of a Class A misdemeanor, the range of punishment for a Class A misdemeanor is minimum 0 days to maximum of 365 days in the county jail, which is 1 year, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, for example, a Class C misdemeanor would be like a speeding ticket. Okay? A Class B misdemeanor, for example, will be criminal trespass. Let's say you go to a store, you see some guys hanging out at the store. The storekeeper told them, they can't be on their property. They still hang out over there. They get arrested. That's a criminal trespass. That's a Class B misdemeanor. Now, a Class A misdemeanor, for example, let's say you assaulted somebody. Okay? Y'all might say it was a fight. You get charged with assault. Okay, that's a Class A misdemeanor, which means they find you guilty, they can put you in jail for up to a year. You fine up to $4,000, or you can be given both such fine and confinement. Okay, so they always say that the felony cases, they are handled in the district court. Misdemeanor cases are handled in the county court. Okay, yes.
I know you said they're right, but can you deny him, the right to represent himself through like, mental matters?
Yeah,
Yeah, mental health issues?
right. Well, that's the primary reason. I mean, if you look in case law, if a person have, they're determined to be incompetent, right? And in order for them to be determined to be incompetent, the court has to conduct what is called an informal inquiry. For example, they come up before the court and the court is observing some strange things. The court has a hearing to determine whether or not there's any evidence to suggest that they may be mentally ill or incompetent to stand trial. We had a hearing, we call that an informal inquiry. We order a doctor, a psychiatrist or a psychologist to do a mental evaluation. They do the evaluation, we get the results back. If they find that they are incompetent, then what has to happen is they will be held in jail, put on what we call a clearinghouse, which is a list to be sent to a facility in the state, somewhere in the state of Texas. Okay, yes.
And Judge, can they be rehabilitated from that incompetency to being found competent?
Right. Once they go to that facility, it's to restore their competence. If they're able to restore their competence, then the case comes back here, right? And now we can go forward. Like at that point, they're competent, they want to represent themselves. And if they voluntarily and intelligently or knowingly waive their right to have an attorney, then they can go forward. Okay. But that was a good question, because that was the main reason why you would not allow a person to represent themselves. They're incompetent. Yes. I don't know, but I don't think all states do. There are some states that don't. I don't know which ones don't.
Yes, if Texas does, Judge.
Oh, yeah, Texas has a death penalty, yeah. That's just a capital murder. Oh, no, this is misdemeanor code. We don't handle those type cases. Yeah. See, we only handle class A, B, and C misdemeanors. Felony court, the district court, they handle the capital murders, first degree, second degree, third degree, and the state jail felony. That's why she asked the question about what type cases do we handle. Yeah. Judge West. Yeah. And Judge Stevens as well. Actually, in some of these other courts, district courts, they have what we call general jurisdiction. And I'll just explain it to you. General jurisdiction means they can handle civil and criminal cases. Okay. But there's an agreement in the county that certain courts will handle just civil and certain courts will handle criminal. Now, except for Judge Stevens, his is a criminal district court. He only can handle criminal cases. He can't handle civil cases. This court here, even though we handle, for the most part, criminal cases, we do handle some civil cases too, because this is a court of general jurisdiction. Actually, County Court 1, 2, and 3 are courts of general jurisdiction, but we have an agreement where most of the civil cases are handled in County Court at Law number 1, and the criminal cases are handled in 2 and 3. Okay. You still working on it?
No.
You got it? Okay. Okay, now we get ready to do a plea. Okay. Okay, Jefferson County Court at Law number 2 is back in session. The court is in session, 3 cases. Cause number 24 CCCR 0208, cause number 24 CCCR 0209, and cause number 24 CCCR 0354. All 3 cases are styled the state of Texas versus Edward Talbin Sellers. Mr. Sellers, is that your full name? Mr. Sellers, would you please raise your right hand? Mr. Sellers, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Sellers, you may put your hand down. How are you doing, Mr. Sellers? You doing all right? That's good. Now, Mr. Sellers, you're represented in your case by your attorney, Jennifer DeLodge. Attorney DeLodge, how are you doing?
I'm doing great, Judge.
And Attorney DeLodge, do you waive a record in Mr. Sellers' case?
Yes, Your Honor.
Mr. Sellers, the state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm great, Judge. Thank you.
That's good. Now, Mr. Sellers, I have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Edward Talbin Sellers, on or about December 22nd of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest detention. Mr. Sellers, do you understand what you've been charged with?
Yes, sir.
And to this charge, how did you plead? Guilty, not guilty, or no contest?
Okay.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Sellers, I also have before me on this tablet a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of this same document, there's a set of initials. I got one initial S.
ES.
It just says
I think he
S.
accidentally erased it. The pen was being funny. Hello, Mr. Sellers, the button.
Okay. Now, Mr. Sellers, the set of initials ES online next to the box is check nolo contendere, which means no contest. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature? On the next document that's titled trial court certification, the defendant's right of appeal. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document? Is this your signature on the line that's titled Defendant? Mr. Sellers, before you sign and initial all of these documents that I just showed you, did your attorney, Mr. Lodge, go over these documents with you? And did you understand everything that she went over? Is everything in these documents true and correct to the best of your knowledge? Mr. Sellers, are you a citizen of the United States?
State offer states one.
Any objections? No objections. States exhibit number 1 will be admitted. Mr. Lodge, you've advised and counseled Mr. Sellers. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Sellers, your attorney, Mr. Lodge, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir.
Mr. Sellers, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 225 days in the Jefferson County Jail, credit for 225 days into tax and retirement court costs. This is running concurrent with the companion case ending in 0209, and the state will be dismissing companion case 0354.
Mr. Sellers, the state is offering that you serve 225 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you've already served 224 days, 225 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. And this case will run concurrent with your companion case, cause number 24 CCCR 0209, and the state will be dismissing cause number 24 CCCR 0354. Mr. Sellers, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Mr. Sellers, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Sellers, we will move on to your next case, cause number 24 CCCR 0209. And in this case, Mr. Sellers, I have a document that is titled Information Sheet. And in this information sheet that was filed by the District Attorney's Office, it alleges that you, Edward Talbin Sellers, on or about December 22nd of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest, search, or transportation. Mr. Sellers, do you understand what you have been charged with in this case? And to this charge, how do you plead? Guilty, not guilty, or no contest?
No, sir.
Are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Sellers, I also have a document before me on my tablet that's titled Misdemeanor Plea Admonishment. You recognize this document?
Yes.
On page 2 of this same document, there's a set of initials ES on the line next to boxes checked. The little contingent rate, do you recognize this document? And are these your initials? On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document. And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case. You have no right of appeal. You understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Also have a document on paper that is titled Discovery Certification. You recognize this document? Is this your signature on the line that's titled Defendant? And Mr. Sellers, before you sign and initial these documents, did your attorney go over these documents with you? And did you understand everything that she went over? Everything in these documents true and correct to the best of your knowledge?
State offer states one.
No objection.
No objection. States exhibit number 1 will be admitted. And Mr. Lodge, you advised and counsel Mr. Sellers in this case. Is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Sellers, your attorney, Mr. Lodge, has advised and counseled you. Are you satisfied with her representation?
Yes.
Has she provided full, effective, and competent legal representation?
Yes.
Mr. Sellers, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 225 days in Jefferson County Jail. Time served, tax retirement court cost is to run concurrent with clause 0208 and dismissal of 0354.
Mr. Sellers, the state is offering that you serve 225 days in Jefferson County Jail. You will not have to serve any more time in the Jefferson County Jail on this case because you've already served 225 days. Therefore, you'll be able to credit for the time that you've already served. The court costs in this case will be tax and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be tax and retired. This case will run concurrent with the previous companion case, cause number 24 CCCR 0208, and the state will be dismissing cause number 24 CCCR 0354. Mr. Sellers, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes.
Mr. Sellers, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Sellers, this will conclude your cases. If you do not have anything else in the jail, you'll be getting out of jail today. Now, Mr. Sellers, you're gonna stand, well, the bailiff is going to bring the judgments to you for your prints and follow his instructions. Once you finish following his instructions, you'll be free to go in the back with the bailiff, and you have a blessed day. All right, and Mr. Lodge, you're free to go and you have a blessed day.
Thank you, Your Honor.
And prosecutors, do we have any bound forfeitures? Okay. Yeah, we have signed the dismissal in that case. Okay. This is it. Here you go. Okay. Kenny Birdwell. That's it must be, he's not here. We didn't have a Kenny Birdwell. Okay. Kenny Wayne Birdwell was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court called the name of Kenny Birdwell at the courthouse door. Kenny Birdwell did not answer. A reasonable time has passed to give Kenny Birdwell an opportunity to appear in court. He has not appeared in court. The time now is 11:56 a.m. on today's date of February 25th of 2025. Mr. Bailiff, would you please call the name of Kenny Birdwell at the courthouse door? Okay, Kenny Birdwell's name was just called again at the courthouse door. Kenny Birdwell did not answer. A reasonable time has passed to give Kenny Birdwell an opportunity to appear in court. He is not appearing in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Kenny Birdwell bond will be forfeited and a warrant shall be issued for his arrest. Next case is cause number 24 CCCR 1664. Jaquez Michael Turner. He's in custody. Okay. Well, that was the last one. This will conclude the calling of the court's arraignment docket in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day. Prosecutors and defense attorney, you're excused. And young men and women, you are also excused. Y'all have a blessed day. Yes, yeah, we can do that.